Hi, Richard Bolger. In this episode, I'm going to talk to you and describe a typical Chapter 7 bankruptcy case. Most cases that I file are Chapter 7, and most of them are so-called no-asset cases. I'll tell you about that in a minute. But before we begin, I have to do two things. I have to do a disclaimer, and I have to give you a notice. So the disclaimer is that realize that bankruptcy law is a federal law. And so it is the same law in Virginia as it is in Idaho, California, Hawaii, wherever, all of the states. However, state law is very important in a bankruptcy case too, mostly because it dictates the way a person's property can be protected in a bankruptcy case. And that varies state to state. There is a federal scheme, if you will, for protecting property as well, but many states have opted out of that, including Virginia. And I'm going to really kind of focus on Virginia because that's where I do most of my work. I also file in the District of Columbia and Maryland. However, most of it is in Virginia. And the notice I must give you is that my firm is a debt relief agency, my law firm, and we help people file for relief under the bankruptcy code. So, a typical Chapter 7 bankruptcy case. It goes something like this. A person finds a lawyer somehow to file their case. You don't have to have a lawyer to file a case, but I think it's foolish not to. So find yourself a good lawyer, somebody who has experience and is highly recommended. These days, you can go look at Google for recommendations and things. You will work with the lawyer to prepare what's called a bankruptcy petition. The better that bankruptcy petition is prepared, the better your case is going to go. And that process includes gathering information for the lawyer. The lawyer is going to need tax returns, most recent filed tax return, evidence of your income. Pay stubs for the preceding 6 months are best, but not everybody has them. And various information about your financial affairs. All that information is elicited by the lawyer from the debtor and is included in the preparation of the bankruptcy petition. When it is complete and all fees have been paid in the case, then the case is ready to be reviewed by the client with the lawyer, and the petition can be signed. I say all fees must be paid in the case because according to court rules, and obviously even common sense, you're supposed to owe your lawyer money when the case is filed. Well, the lawyer's fees would then be included as a debt and discharged along with the rest of the debts. So, I mean, kind of common sense, And so once the fees have been paid, and let me just make one comment about fees real quick if I can. There in Chapter 13, there's Chapter 7 and Chapter 13, right, which are the primary consumer bankruptcy codes, bankruptcy cases. In Chapter 13, an attorney's fee can be included in the actual Chapter 13 case because it's a repayment plan, a reorganization, and monthly payments are made, and the attorney's fee can be paid out of that. In a Chapter 7, it's a liquidation. The attorney's fees have to be paid up front. Be wary of lawyers that will say, you don't need to pay me much more than the filing fee to get the case filed, and you'll just pay the attorney's fee in the case. Take a good hard look at that, because the attorney's fee of Chapter 13 in Northern Virginia well, in the Eastern District of Virginia, is over $5,000. And a Chapter 7 case, the fee is, less than half of that. And so don't be penny wise and pound foolish by saying, I will go with the case that costs less up front, because you're going to end up paying a lot more in the long run, is what I'm saying. I know you have to pay all the fees up front in a Chapter 7. You don't in a 13. It might seem appealing at the time, but in the long run, you're not making a wise decision. If you can get a quick discharge in a Chapter 7, and the only thing is holding you back is the fees, just save your money till you get the fees and file. That's the best way to go. So once the case is ready to be filed, reviewed by the attorney with the client, they do that and a thorough review, and then the document is signed. And at that point in time, as long as you've signed your petition, paid your fees, I forgot to say one more thing, you have to take a pre-filing bankruptcy class. Okay, it's a 1-hour class. You can get it online. It's less than $20 to take the class. You must spend the whole hour, no giving it short shrift and rushing through, even though I find it of very limited usefulness. It is a requirement. So you've taken the class, paid the fees, you reviewed your petition with your lawyer, and you've signed it. The lawyer then will file the case. This is done electronically and can be done from the lawyer's desk. At that point in time, upon the filing of the case, what is called the automatic stay goes into effect. The automatic stay is a nationwide injunction without notice against all efforts to collect money from you. It stops garnishments, foreclosures, lawsuits, and the purpose of it is to give the person who filed the petition a breathing room while the court sorts through the bankruptcy case. The court will immediately then send out notices to all of the creditors in your case, and will also schedule at that time your hearing, which is generally about 30 days after you file. After you file and before the hearing, you should take your second class, which is a 2-hour class, and you're going to be working with your lawyer to prepare for your hearing. Again, the better preparation for your hearing, the better your hearing will go. The better your petition is prepared, the better your preparation for your hearing, the better your hearing will go. The hearing is the one time where people are most nervous about the whole process, because they're going to be put under oath at the hearing and answer questions. Now, once the documents are the case is filed and documents are given to the lawyer to prepare for the hearing, the hearing is scheduled. The hearing is before a person known as the trustee. The trustee is appointed in the case to review your petition, and that trustee is looking primarily to see if you have assets which can be liquidated and the proceeds therefrom distributed to your unsecured creditors. The hearings these days are, because of the pandemic, are conducted on the telephone. They used to be in person, but they are not now. And so you are going to be participating in your hearing from wherever you have from your home. You could do it from your car. The point of the matter is that it's not in person. You just have to have a phone that you can mute and unmute, as the case may be when necessary, to participate in the hearing. At the hearing is about a month after the filing. At the hearing, you will generally be scheduled in a 1-hour time block, and there will be anywhere from 5 to 15 other cases scheduled for that time period. Usually around 8 or 9 or so cases. So you can tell if you have 8 cases per hour, they're not going to most of them are not going to last very long. And in my opinion, the better trustees have thoroughly examined your petition and know if there's going to be something that they need to drill down on or not before the hearing even starts. Now, you will be, as I said, present by your telephone, and your lawyer will be present by phone as well. You do not have to be in the same place. And I am generally not. I'm generally Mr. Socially Distant at this point in time, and there's no need to be available, in person, sitting side by side for a telephone hearing. I think it's safer for the client, safer for the lawyer, and everybody involved if you are in your own little bubble during your hearing. So, the questions that you'll be asked at the hearing, what are they? Well, there are a lot of standard questions. First, you get sworn in. You swear to tell the truth under penalty of perjury. And you are asked things such as, did you review your petition with your lawyer when you signed it? Did you list all of your property as well as all of your debts? Are you still living at the same address? What is your phone number if I need to get a hold of you? Do you own any real estate? Then they start going through your real estate if you have any. How much is it worth? What do you owe? And so on. And then after real estate, they typically look at cars and look at the value of cars and whether they are have a lien against them or not. And they look primarily for assets that can be easily liquidated. So they're generally not very interested in your 20-year-old sofa, okay, or your 5-year-old computer, or your probably even 1-year-old television, because those things depreciate in value so quickly. I often tell people, do you have any assets in your house that are worth more today than they were last week? And that generally, the answer is no. And so we list everything thoroughly. You must list all of your property, like I said, as well as all of your debts. And you'll know going in, assuming you have a competent attorney. I always know going in what the trustees are looking for, because I quizzed my client at the very outset of the process to know if there's something I need to worry about. Where are the assets? What are they consist of? What are their values? Can I protect them? I want to know that all up front, and so do you, before I file the case. So really what's happening at the hearing should be anticipated ahead of time. And, I do see hearings from time to time where surprises happen, and people don't like surprises at their hearing. Now, that hearing is probably the only hearing you're going to have. It's called the meeting of the creditors. And generally speaking, creditors don't show up. It's really a meeting between the debtor and the trustee, although creditors do have the right to appear and ask a limited number of questions, and sometimes do, especially creditors who are not sophisticated commercial lenders. They're like, your buddy Frank, who you borrowed money from and you had to list as a creditor. Well, probably your ex-buddy, I would say. They might not be so happy to be discharged in bankruptcy, but they might just show up and go, am I going to get paid? And that happens from time to time. Sometimes an angry former spouse. Those happen too. So after that hearing, basically, generally speaking, you have about 60 days to wait before you get your discharge, because creditors have the right to file objections. What kind of objections? What creditors will file objections? Well, there are non-dischargeable debts, and that is a whole nother episode in and of itself. But if all goes well, the 60-day time period will come and go. You'll get your discharge order, and that's the end of your Chapter 7 case. That is a typical no-asset Chapter 7 bankruptcy case. I say no asset, meaning that no property that the debtor owned was liquidated by the trustee, and the case was closed without any distribution to creditors. So once in a while, there are asset cases, and those are ones which are part of the plan. You know going in, you're going to lose this asset or that asset, and that can happen. But it's a decision you would make after advice and consent and you know what's going on. So that's it for now. We'll be talking about more in an upcoming episode. Talk to you later.